We're on?
We are.
All right. Good evening to everybody who has joined us from afar. My name is Erin Thrash, and I'm here tonight with my partner, Mike Carroll. This is our first virtual Wine and Wills. So typically, we give our Wine and Wills as a casual event in a neighborhood, and it's usually hosted by one of our clients who invites their friends and neighbors over to get an opportunity to talk to a lawyer without the intimidating atmosphere of a legal office and a fear that it's going to cost you money. So it gives them an opportunity to ask those questions that they might feel like are stupid questions, and which we think are all brilliant questions, of course. And the best part about Wine and Wills in your neighborhood is that we bring the wine. But tonight, because of social distancing and because of COVID, we can't have those gatherings. So we're expecting you to bring your own wine, to sit with us, and feel free to ask us as many questions as you feel comfortable asking us. And you don't have to wear your Frito Bandito mask. So get your slippers, get your bottle of wine, and let's start this off. Now, this only works if you ask the questions, but we're going to start tonight with a little presentation, giving you kind of an opportunity to get warmed up and to kind of understand what we're talking about. And then I think Mike, my partner, is going to tell you how to ask the questions, get our attention, and where we go from here. So, Mike?
Okay, thanks, Erin. So if you're familiar with Zoom meetings, if this is something that's you've become COVID aware of, you know that the person talking generally pops up on the screen. And one of the things we want you to know is that we want to preserve your privacy, and we want you to know that we will be recording this proceeding, and we will hopefully be posting it to our website so that other people can view it and participate in that as well. And so we're not sure if you want to or would feel comfortable in appearing on our website and all of that sort of thing. So what we're going to do is, instead of fielding questions orally, we're going to get you to raise your hand and do it via a chat. So I'm going to open up the chat line, and you should see a chat line as we go through there. And so if we're going to do that, all you have to do is just pose a question. We'll sort of see a streaming view, and we'll try to get to as many of them as we can. If we don't answer your question or we didn't get to it, you can always email either Erin or I, or anybody at info@tcvlaw.com, and we'll try to personally answer your question if you want it answered. And of course, we always offer free consultations to people who are considering doing some planning. So if you want to take advantage of that, you can certainly do that as well. So we hope that you will participate, because like Erin said, the real fun of these things are when people start asking questions and getting down in the weeds. We don't want to just lecture you on estate planning, but we want to field your questions. Because there are a number of people listening, you may want to be a little careful about all of the information you share about your question. So feel free to be a little careful about what all you choose to share. So Erin, I'm going to try to get to our slideshow, and we're going to start with a basic understanding of key terms in estate planning. So if I know what I'm doing, I'm going to do that, and I'm going to go here. And so would you tell us what these key terms mean?
Is that sharing? Because I'm not seeing it, but I will tell you what they mean.
Okay, well, we want to share it, so let me get to the right button and try to figure out how to do this. Lawyers with technology is a dangerous thing.
All right. Well, in the meantime, let me tell you what terms that we're going to go through, and we're just going to go through the very basic ones. So the first one, of course, that you think of primarily when you think of estate planning is a will, also known as a last will and testament. This is a document who directs how and who, you got it.
All right.
How and who you want your property distributed to after your death, and who you want to be in charge of making those distributions. There are very specific formalities that a will must comply with, and it often changes state to state. A will has to go through probate. And probate is the legal process of proving up a will where the court declares the will is valid and legally binding and orders the person appointed, the executor, who you've named in your will, to distribute the property in accordance with the provisions of the will. All of these documents that are a part of a probate proceeding are public record. The third term we're going to go through is trust, also known as a revocable trust, also known as a revocable living trust. A trust that is in existence now, a trust is in existence now, that's why it's called a living trust, and it's revocable and amendable during your lifetime, which is why it's called revocable. That would be a duh, right? This trust directs the distribution of your property during your lifetime. Then it also directs the distribution of your property after your death and designates a trustee to make those distributions in the event of your death. During your lifetime, however, you're the trustee and you continue to manage your property. You just do it in the name of a trust. Incapacity. Everyone always wants to know, what does incapacity mean? Am I incapacitated? Is mom incapacitated? Incapacity is usually by virtue of age. So a minor child or a child in Texas under the age of 18 is incapacitated, whether they're brilliant or not. Mental defect, which is caused either by accident or disease, or just elderly. A person can no longer manage his or her personal or financial affairs. The reason incapacity is important because it plays into powers of attorney. So when we do an estate plan for you, we always include your powers of attorney to make your medical and financial decisions. The powers of attorney include several documents, but they are legal documents where you designate who you want to serve to make medical or financial decisions for you or to serve as your agent. This also includes your guardians for your minor children who are legally unable, obviously, to make those decisions until they're 18. So Mike, the first question I always get when I do these wine and wills is, do I need a will and why? Go for it.
All right. I think the answer to that is obviously yes, because everybody has a will. You may not know that, but your will is either the one that you draft for yourself, or it's what the state of Texas says you get if you don't have a will. And if you do not have a will, then the state's statutes say who inherits your property when you die. And the problem with that is twofold. Number one, when you have a will, it says, I leave my property to my wife or my husband or my children. That's pretty clear because you've identified them in your will. But when you are leaving money under the state plan, the court has no idea who your heirs are. So it has to hold a proceeding called a proceeding to declare heirship and try to figure out who your legal relatives are. And number two, that sort of proceeding is what's called a dependent administration, which means you have to file a bond, you have to do a lot more requirements and get a lot more permission from other people in order to do things on behalf of an estate. Whereas if you have a will, most people say you just to serve independently, and so it's a much easier, simpler, more cost-effective kind of probate proceeding. So I would say absolutely you need a will to do exactly what it is that you want. So if we're going to talk about sort of why we need the kind of will, or sort of what we are dealing with, we need to think in terms of how do things work with actual real life situations. And so we've got obviously a slide of, here's one of them, if my slide will change. All right, so let's suppose that for some reason we are out on a date night and we have a terrible automobile accident. We're both in the hospital, and or perhaps deceased. The babysitter is there frantic because no one has come to take care of the kids. They were supposed to have been home hours ago. So I mean, these are the sort of situations in which we're talking about how to deal with these kind of issues. So Before we get to that, though, I wanted to kind of figure out and go back to the situation of, say, fatalities and not having a will and how we make wills. And let's talk about maybe a horror story. Erin, do you have a favorite story maybe about somebody who did not do a will, didn't have one?
Well, I have a combination story. It's the story I tell everyone is going to curl your hair. So the scenario is a gentleman, they're both gone now, so I'm not telling stories out of turn here, but the client came in, or a client came in, he decided to draft his own will, and so he didn't engage me. He went home and drafted his own will, and his will said, I'll leave everything to my second wife, and when she passes, I want it to go to my children. And he had 2 children by a previous marriage, both adults. He had a little over $5 million. He died. His wife inherited his property. She did not have a will, and she had come to us for the probate. So we were doing the probate, and she had decided who she wanted to be her beneficiaries, which were the 2 children of the previous deceased, her deceased husband. And before she could get in to sign the will, she died. Her estate, basically his $5 million went intestate, which is the state of Texas plan for your assets. The state of Texas plan for her assets gave it to her second cousin who she'd only met twice. And on the other side, it gave it all to her father's heirs, and there were 28 of them. The problem with that is her father had deserted she and her mother when she was 18 months old, so she doesn't remember him at all. He had never, ever paid a dime of child support, etc. And $2.5 million went to his heirs or to his relatives, her relatives on that side, whom she'd never met. So that's what I call a true horror story, because you know that he was rolling over in his grave, or turning over in his grave, as they say, because of that horrible fiasco. So the state of Texas plan is usually pretty good unless you have a scenario, it's pretty normal unless you have a scenario where the people that your family members are not people that you would like to leave money to.
Yeah, okay. Of course, the next, the next worst thing, I guess, than having nothing at all is using one of the online form things to try to do your estate planning for you.
LegalZoom.
That's the one, everybody, that comes to mind. I remember having one in which a guy tried to do it himself, and he was a fairly young man, had a child, I'm calling Bobby, and so he wrote his will using the LegalZoom software, and so it smartly identified the definition of children to include not only Bobby, but also any children that were born to or adopted by him after he wrote his will. And of course, he did have 2 more children, but when he left his estate in his Zoom will, he didn't leave it to his children, he left it to Bobby. So his will provided that Bobby got everything, and his 2 siblings were left out in the cold. Now, fortunately, that's a situation where we got to fix it before our client's demise, and Bobby, unfortunately for him, did not get to keep all of the money to himself. So that's sort of my horror story. I had another one in which I guess is sort of a DIY situation. I don't know, it involved a blended family, a gentleman who was deceased before I ever got involved in the situation. Apparently, if we assume that he knew and intended to do what he was doing, left his home, which is a substantial asset in his estate, to his 2 children, 2 boys. And he also then left, by beneficiary designation, his IRA or 401k, I can't remember which, to his new but much younger second wife. And so if his plan was to give the house to the boys and the IRA or 401k to the wife and thus provide for everybody, his plan failed miserably because his wife, who was only about 10 years older than the two children, filed a claim to live in the homestead for the rest of her life. So even though the children inherited the home, they'll get to sell it maybe in their 70s or 80s if they're lucky. So just an example, another example of poor planning that has gone awry. So just another reason why it's important to have a will and to have the will that's done right. And I'm going to go back to a slideshow and go back there to again and try to just do a few more talks about, or a little bit more conversation about incapacity planning, because that's as equally, if not more important than the death planning. Before I do that, though, I'm going to open up the chat line. So if questions are coming to you and you want to start asking questions, I'm going to let you do that. You can just type them in and we'll try to get to as many of them as we can. So look, I'm seeing a few highs and hellos, so we're glad to have you with us. And then I'm going to go back to trying to share my screen here and see if I can pick the right one. So let's see if this is the correct one.
In the meantime, can I tell a beneficiary disaster?
Sure you can.
Your screen has shared. Go ahead.
But you can still tell your story.
My beneficiary disaster story has a gentleman with a $2 million IRA who had his beneficiary named as his first wife. He married a second wife, stayed married to her for 20 years, worked for a Fortune 500 company, but never checked his beneficiary designation. Although Texas law says that if you divorce a spouse, if you're not under a federal plan, you can actually disinherit your first wife just by virtue of being divorced. If Texas law also says that if you go back and reconfirm that beneficiary designation, then it will stand. In this case, the gentleman went through his cafeteria plan every year and changed his health care and his eye coverage and his dental coverage, etc. And when he died, 20 years married to the second wife, and the first wife was the original beneficiary, the argument was, of course, that he really intended his second wife to be the beneficiary. And the court said, nope, he had ample opportunity to change it. Apparently, he meant to keep it that way because he had changed everything else. So note to self, be careful about beneficiary designations as well. And that's one of the things that we do when we go through your plan, is we examine your beneficiary designations and get confirmations, and then we tell you what we think the appropriate ones are to coordinate with your plan. So, sorry, Mike, go ahead.
No, absolutely important. A very important thing to do to make sure, because it all has to sync up in order for it to work correctly. So let's go back to a situation where we were kind of discussing a few minutes ago about incapacity planning. And so we're talking about guardianship and who's going to make decisions and raise kids and all that sort of thing. You know, one of the first things we think of, and one of the first things that motivates young couples to do this kind of planning, is who's going to take care of my kids if something happens to me, if I'm disabled in an automobile accident or something like that. So assuming that happens, we've got a situation where we have to have somebody to step in and take care of the kids and to make sure that the kids are cared for. And that person is generally a guardian. And so as parents, we can designate guardians for our minor children. And a lot of people think that that's really just one job, who will be the guardian, but oftentimes it's really 2 or 3 jobs. It's, you know, who's going to be the guardian of the money to take care of the kids, who's going to be the person to get them dressed and get them to school, not necessarily the same person. And if we have a situation where a guardian is either, number one, is her mother in New York or his mother in California, then to address the situation that we're looking at now, maybe we also need a temporary guardian appointed, which is what we generally do when that situation arises, so that we've got somebody there to take care of the kids in this sort of an emergency or temporary situation before somebody gets here from California or New York. And of course, now one of the things that we're also worried about for ourselves is if we find ourselves in the hospital and emergency room on the ventilator in an induced coma because of COVID or some other reasons. You know, adults need somebody to make financial decisions for them, to keep the bills paid, pay the rent, pay the car, keep our credit from getting shot. We also need somebody that's there to make medical decisions for us. And so the way we generally provide for those things is with both medical and financial powers of attorney and declarations of guardianship to sort of reinforce that, because the option is, if we do not have a medical and financial power of attorney and we become disabled, you know, we need somebody to be able to step in. And particularly with a lot of young couples, they say, well, look, if I become disabled, you know, my wife can handle all this, or my husband can handle all this, and so I don't really think I need a financial or a medical power of attorney. But particularly with financial powers of attorney, if a young couple's wealth is substantially tied up in their house, which they would not be able to sell without a guardianship, or a 401k that designates the spouse as the beneficiary, but you know, if the disabled person is not deceased, then that doesn't give the beneficiary the right to withdraw any funds for it. And so the medical and financial powers of attorney take care of allowing us to act for each other in marriage and family situations. And the result of not having done that kind of planning is that we have to go have the adult declared mentally incapacitated, and you have to apply to have that person declared legally incompetent. The court has to appoint another lawyer that you pay for to represent the disabled person to make sure that you're not trying to take advantage of them. You have to post a bond and renew it every year. You have to seek court permission and then provide an annual accounting, and you know, and really a detailed accounting with financial backup every year. So needless to say, a guardianship proceeding is a very expensive guardianship that we want to avoid if at all possible. So we're going to kind of open it up for questions here, and I'm going to kind of let everybody do that. We're going to go through them. So I'm going to stop screen sharing there and look down. And Erin, you field the first one. I'll look for another one, and let's see what kind of questions we get.
So the question I'm getting here is, how do I choose guardians for my children? So one of the things, I have a new grandchild and I love my grandchild, but one of the things that I told my son is, because I am elderly according to COVID, unfortunately, is that probably if something were to happen to him, it would not be a good idea to choose me or me and my husband as guardians, because a child has just gone through a traumatic event. He's lost his parents. And if he goes to live with an older guardian, even though mom and dad seem to be the most reasonable at the time, we may not survive to the child's 18th birthday. We may get too old to handle a teenager, etc. So I typically tell my clients that look at the age and the circumstances, and then find either a sibling or sometimes a friend from church, sometimes a good family friend. Sometimes people's real concern is keeping the kids in Austin, Texas. And so we want to find somebody who's domiciled in Austin, Texas, kind of referring back to what you said, moms in New York and the other moms in California. It's really hard to keep the family together with that kind of relationship. So if the guardian lives at the deceased's home and raises the children there, so some of those things are very important. So I would always you can always look outside the family for good guardians for your kids.
Okay. All right, so I'm seeing a question here about somebody who wants to buy a duplex for a investment property, wants their daughter to live in part of it and use the other side for income, but wants to make sure that when the daughter dies, it goes to their grandchildren. Can they do that? And is that possible? And yes, it is possible. So, you know, you have a right in a will to control how property is disposed of. And so, you know, the typical ma and pa or sweetheart will, it just says, I leave everything to my spouse or to my daughter, you don't have any control. But instead of doing it that way, you could purchase the duplex, allow your daughter to live in half, and then either through an inter vivos living trust or a testamentary trust within the will, say, I leave the duplex in a trust for my daughter. My daughter will be able to live in the house, but then at her death, that duplex then goes to her descendants in equal shares. So you can do that really easily just by the terms that you are setting up the terms and conditions on how you give things to your daughter. So that can really easily be done. All right, Aaron, pick your next one there.
I see a question that says, can I have my kids make decisions for me together? And I love that question because that no matter how large your family is, if your kids make good decisions together, of course they can make those decisions together. One of the issues though becomes, well, what if they get deadlocked? If you have 3 kids, is it a majority vote or a unanimous vote? Or if you have 6 kids, what if it's 3 against 3? And so you have to be cognizant of some of those issues as well. But yes, your kids can always make decisions for you. We do like when you have a medical situation, we do like, and you name 1 or more or 2 or more children, we do like to say that, well, one of them can make the decision after consulting the other so that we have a person or a child that's at the hospital making those decisions immediately when the others maybe can't get there. So you have anything to add to that, Mike?
Yeah, I would just say, sometimes that works pretty good with a couple of kids, and you don't want to mistreat anybody. You don't want to pick a number 1 and a number 2. But you have to be really careful about medical powers of attorney decision-making by committee, because if somebody is, if they can't get the whole committee there, and so then well, wait a minute, we got to find Johnny in order to be able to get the unanimous decision. So that can be problematic. So I would be really careful about that. So. I see another question here that says, what paperwork, documents, information should be gathered in advance to start estate planning? Well, yes, there should be some information gathered, and it can be found very handily on our website under the resources tab, estateplanningAustin.com. There's an estate planning workbook. And so, I mean, letting people know, this has some basic questions about what my family situation is, or my children, our children, are they blended children of his or hers? What our assets consist of? What are our concerns? Are we worried that our children don't handle money well? A lot of questions like that. Who might we want our agents to be? So it's always helpful to kind of look at something like that and sort of start thinking about who you want to make certain things. I don't want anybody to ever make those decisions like they're written on a rock until they talk to us. Because, a lot of times those decisions are better made after we kind of have these conversations of, tell me about your kids, handle money well, not handle money well, mature enough. When do you think they will be mature enough? And we can have really intelligent feedback and then sort of jointly make those decisions. So the workbook is just a starting spot. It's not where you just decide what you want to happen and we write it up for you. But it is a good starting spot. So you can look for that under the resources tab on our website. Aaron, you want to take the next one?
Yeah, I see one that says, I have a special needs child. How do I take care of him? So we tend, because most of our clients are worried, or are blended families. We're in a very wealthy area. And there's usually a lot of money, or some significant amount of money. Of course, with some kids, $10 is a lot of money. But either way, that will go to the children. So we typically recommend that children receive their inheritances from their parents in a trust. There is a special type of trust called a special needs trust or a supplemental needs trust that deals specifically with children who are going to be permanently disabled. And who are receiving federal benefits. So when a child is in that circumstance, or potentially in that circumstance, we have either a contingent or we set up a supplemental needs trust for that child. So that's how we take care of that. But there are special provisions just for those types of situations.
Yep. All right. So I'm seeing lots of questions pop up. We're going to try to get to all of them. I see a question that says, to update my will and trust, is that something I come to your office, or do we do that our own? And how often should we review these? I would certainly encourage people not to try to do that on your own. Number one, just to have a review meeting at us is complimentary. So why would you want to try to struggle through it on your own if you can at least get a little advice about that? And a lot of times it's not the things that you know personally about how your situation has changed, but it's what's changed in the law that you don't know about. And I'm looking at another question a couple down that we're going to get to. It involves a law change, and we're going to be answering that here in just a minute. But that's one of the examples of a kind of question that you wouldn't really know to think of on your own unless you just happen to read an article or a news piece about that. So I would say you should definitely do that through a law office. How often should we review these? You know, I'd say the average I see is way too long. It's maybe 20 years. I mean, you need to have it looked at more than every 20 years. If there's a significant change in your life situation, it's time to have it looked at. If there's a divorce, a death, a new child, you know, a significant increase or decrease in wealth, it's time to have it looked at. I usually tell people, you can call me anytime you want. If you don't call me in 3 to 5 years, I'll probably be calling you saying I hadn't heard from you in a while. Let's visit about that. So I think you should get these reviewed every 3 to 5 years on a regular basis. All right, Aaron, pick your next one.
I see. What happens to any unlisted assets? For example, if I leave my home to my wife, does that also include everything in the house that isn't explicitly listed? And that's a really good question, because that's the kind of thing that happens when you try to do a will on your own. So what our wills or trusts would say is, if I'm leaving a homestead for my wife, that also includes the tangible personal property. And the really funny story I've got about that, except it wasn't funny at the time, is that I had a surviving spouse who went to the funeral with 2 of the 4 kids by the previous marriage for dad, and the other 2 kids stayed home, rented a moving van, and emptied out the house, because the will or trust, which I did not draft, by the way, said I leave her the house, but did not say that I leave her the furniture, furnishings, appliances, etc. So the refrigerator, the washer, dryer, couch, chairs, and everything else were taken by the 2 kids. So what we tend to do is be very careful about that, and we always leave what's called tangible personal assets to whomever the testator or the person whose will we're drafting wants it to go to. There's also something we call a personal property memorandum, so that you can list things that are really important to you. My Rolex watch, my diamond earrings, things that are important to you that you want to leave to a specific person. And you may not want to leave your golf clubs to your wife because she doesn't play golf. Although in Mike's case, apparently she's better at it than he is. Sorry.
I still beat her now.
Okay. But so his wife may not want his golf clubs, and so maybe his son does. So he would do a personal property memorandum to leave his golf clubs to his son. So that's, I hope that answers the question, but it's a tangible personal property memorandum, or we do address it in the terms of the will. I leave my home and all the contents to my wife.
Okay, good answer there. All right, I'm seeing another question. That's one that I saw a few minutes ago that sort of alluded to tax changes that you may not be aware of. We've got a question about the changes to the 401k laws requiring distribution or withdrawal of funds within 10 years of my death, and a concern about leaving something to the niece and other changes that relate to that. So that's called the Secure Act is what passed that. And the Secure Act says that if you leave an inherited IRA or 401k to your spouse can still get more than 10 years. They can take that money out over their lifetime. Their required minimum distributions will be calculated accordingly. But children who inherit IRAs have to take them out over a 10-year period that begins on December 31st of the day of of the year in which the parent died and ends 10 years thereafter. And so there are exceptions to the 10-year rule. And so one of the ways that you plan is we mentioned a niece in here, and I don't know how old the niece is, but one of the exceptions to there are several exceptions, leaving money to a disabled person, to a minor child, to a chronically ill person, and we don't really know exactly what that means until the Treasury regulations are published after much debate, which will be 2 years from now. So once all that's sort of sorted out, then maybe we'll have a little more definition. But it's very important, yes, to plan with those funds, knowing that the kids may have to take that over a 10-year period. So oftentimes you'll want to look for children who may get more than the 10-year stretch and make those the beneficiaries of those plans or trust for those. So if you have a special needs child and give them all or a disproportionately large part, or a minor, the minor gets to their 18 and then 10 years after that. So there are ways in which you can work that to make it less than a mandatory or fixed 10-year period. The other thing that you can do or have to remember is that you can sort of manipulate this a little bit by using Roth IRA conversions, because this sort of is a function of how much of your wealth is in your IRA or 401k and how many children you have. So if you've got, 600,000 in your IRA, you got 6 kids, so we're dividing by 6, then we divide by 10, and our children are not high wage earners, maybe we really don't have a problem and we don't need to worry about it. What I really worry about is when people have a really disproportionately large part of their wealth in an IRA and 401k, and they got 1 child or maybe 2 children. Because when people die in their 70s, 80s, 90s, a lot of time they're leaving these to their kids in their late 50s to 60s. They're hitting these kids in their prime earning years. So I had one in which they had 1 child, and she was a lawyer, I think, in New York City. Well, guess what? She's going to be making a ton of money, and all this inherited IRA, she's going to have to take out that on top of her other earnings, and she's going to have to pay the maximum tax rate on all of that. So one of the things that you can do to sort of work around that is do a gradual Roth conversion. Wait till you retire, you're not earning money anymore, maybe you're not drawing out a lot. Figure out what you think your child's tax bracket will be, what your tax bracket is now, and if you want to convert up until the next tax bracket or until you get in a higher, equal or higher to your children, go ahead and start that conversion and let your kids take that out. That's just one of the strategies that are available to sort of buy yourself some better terms for your children. So, Erin?
Well, that's the segue from that is that we do a lot of income tax planning in an estate planning concept, more so than when 40 years ago when I started practicing law, when the estate tax was scary because it was 55% of your estate, and it started at 600,000. So now, and that's actually one of the questions I see here is I heard about an annual gift tax limit and estate tax limit. What are they? So the estate tax limit this year, as opposed to when I started practicing law, is 11.58 million. So per person. So in a married couple, you can actually protect 23.616 million, which is a lot of money, and most of us will not be subject to that tax. The caveat to that, of course, is that if the Dems take over the Senate and the presidency, that may change. Plus, the Secure Act was kind of overshadowed by the CARES Act and has added about $3 trillion to our national debt. So there's going to have to get the money from somewhere. So anyway, we are doing some income tax planning, which is what Mike was talking about with our estate tax planning. One of the tools that we use, so I'm getting to the answer to this question, one of the tools that we can use, especially in a little bit, well, in a lot of ways, is the annual gift tax limit. So I don't know how many of you get that $10,000 check from, or used to get the $10,000 check from your mom every Christmas. Well, that was an annual gift tax exclusion at that time. It is now $15,000 per person per year. So you can give up to $15,000 to any person that you want. And we use that annual gift limit a lot for estates to try to either buy life insurance to leverage out the estate tax or income tax consequences, and or to just get assets out of your estate. So the annual gift tax limit is $15,000 currently. The estate tax limit this year is $11.58 million. So $11,580,000 per person, which are pretty high numbers. Like them a lot.
All right, so I'm seeing another question here that says, if I have a few single friends in their 20s, no kids, not a lot of assets, what should they do? Okay, so great question. So how do we do that for people who really are just sort of starting out in life, and what do they need? So one of the first things, you know, for single people, young single people, even though they don't have a lot of money, I mean, if they're single, they don't have anybody to that has the legal ability to take care of them when they're adults. So I almost think it's more important for them than having a will is to have their powers of attorney in order. And so, you know, and this is, nothing could be more critical, especially when the parents are in a state like California or New York or halfway across the country. So, you know, roommate says, little Sally has been taken to the hospital. Mom and dad, who live many miles and states away, are absolutely panicked. They call the hospital to figure out what's wrong with little Sally. Well, the hospital won't talk to them because she's an adult. They don't have a medical power of attorney. They don't have a HIPAA-compliant medical authorization. And that does not set well with a mother whose daughter is in trouble thousands of miles away, I'm here to tell you. So having that sort of incapacity planning to make medical decisions is a hugely important thing. And then if they're single and they have no spouse or anybody else on their checking account, the question is, who's going to pay the rent? Who's going to keep the car that has car payments from being repossessed? Who's going to make sure that the child's credit doesn't go down the toilet? So your incapacity planning for people at that stage is really, really critical, even if you don't have any property. And so there are ways where people like that we can sort of maneuver around their lack of assets and get them something that will take care of them until they have spouses and children and or more assets, and they have something that's worthy of protection. So just one way that we can sort of handle that. Aaron, you want to take the next one?
Oh, I see. What do I charge? I love that question. That's a hard question, actually, because charging for a will or a trust is something that that I can't tell you that we have a specific charge right now. Typically, I recommend that anyone who wants to talk about a will or a trust take advantage of our complimentary initial meeting, because at the end of that meeting, I can tell you exactly what it's going to cost. But it typically depends on the complexity. It depends on the size of your estate, how many people you want to leave it to, whether you include trust, special needs trust, tax planning, etc. So that charge is kind of, it's defined by the end of the meeting, but it's hard to tell you just right now what it will be. So.
All right. Looks like, oh, let's see, maybe another new message. Looks like we've kind of gotten to most of them. So if you're wanting to ask a question, you're sort of running out of the time. We're not going to keep everybody held to do that. So I'm going to give you a few more minutes to sort of ask a question while we kind of scan one. Here's, how is a trust different from a will? All right. So we'll give you, answer this question and give you a little bit more time. So a will is sort of what most people are familiar with. It just says, whatever I've got hanging around that's mine, I'm going to say who gets whatever that is. So whatever's in my probate estate, which doesn't necessarily include non-probate assets that are beneficiary designated, but it covers the house, the cars, and so forth. So a will is not valid until a judge says that it is valid. So you have to file it, an application to have it probated, and you have to get appointed an executor or a person in charge of the will, be appointed and get issued what's called letters testamentary, which is your badge of authority to conduct business on behalf of the deceased person's estate. And that allows you to have the power to gather assets, and it starts a string of requirements for notification of heirs, notification of secured creditors, publishing notice in the newspaper, completing an inventory, appraisement, and list of claims, and that sort of thing, until you are able to gather and then just pay the bills and claims that are made against the estate, and to distribute all of the money to the heirs who are pointed out in the will as the persons entitled to receive the property. And so when we say wills or trust, I mean, sometimes wills can include trusts. Wills can go from a simple, if I leave everything to my kids, but if any one of them is younger than 20 or 25 or 21 or whatever age that you pick, it will be held in trust for them until they get old enough to take it. Because if you leave money to a 3-year-old, the court's not going to turn over money to the 3-year-old. Life insurance company is not going to pay the 3-year-old. There'll have to be a guardianship taken out. So most wills have a contingent trust in them to take care of that. When you say trust being different from a will, they can be components of it, but primarily that talks about creating a trust in which you put your assets now while you're still alive. You appoint somebody to be your trustee, which is typically yourself, and you manage your assets. And when you place your assets in the trust, it's not really a company because you don't file anything with the Secretary of State, but it's a relationship between the person who makes the trust, the trustee, and the beneficiary. And so then when a person dies, you just change officers. So mom and dad are both the trustees of their trust. Dad dies, mom becomes the trustee. Your trust says that daughter number 1 becomes a successor trustee after mom dies. And then that successor trustee then divides the money amongst the kids. So it's a way to get around the probate process and to place everything into a vehicle which requires no court approval, no court supervision, and sort of operates on its own accord. So, Erin, did I do a decent job with that, or you want to clear that up a little bit?
The difference between a generic trust, there's 2 different types of trusts in that regard. A revocable trust, which is your estate planning trust, and an irrevocable trust, which kind of leads you to an estate, is what it says. It's irrevocable, and it leads you into an asset protection realm, which actually some of the new questions are more leaning towards asset protection versus estate planning, so we can get to that. But so what Mike was talking about was a revocable trust, which is an estate planning trust. And we use those now primarily for privacy. So because we don't want to go through the probate process and advertise to the world as a public record what we own in our estate, we typically will put everybody a lot of our clients will choose or opt to be in a revocable trust. So that's, yeah, you did a great job. It's just revocable trust. And I defined it in the beginning. So I wanted to make sure that I pulled that in. And then the question I'm seeing is, if you have rental property, should you put it under an LLC? Like I said, that kind of tends towards the asset protection part of our practice, which we do. And the answer, of course, is a generic yes or an absolute yes, enthusiastic yes. One of the things that we worry about when we look at your estate is things that will cause you to lose assets of your estate during your lifetime. And so asset protection is what we call defensive estate planning. To do defensive estate planning, we typically recommend that people put each of their assets or a number of their assets in different buckets that protects them one from the other. So if you had a rental property and somebody fell off the balcony, off the deck, and they sued, and you owned it outright, and they sued you for $10 million because their son was now a quadriplegic, then you would lose everything else in your estate. If you have your rental property in an LLC, on the other hand, the rental property and the child fell off the deck and was a quadriplegic, then if they sue you, they sue the LLC. And they can't get past your LLC to your personal assets, but they can take your rental property. But that's a much better result than everything you own endangering your life and your estate. So, of course, we always want you to have liability insurance too. But a rental property, if you have a ranch, you have a lake house, if you have property in Colorado, especially if you rent it to other people, any of those things all need to be in their own separate bucket.
All right. I'm seeing a question here that indicates somebody has a fairly high level of understanding of estate planning, because this is not a basic question. When is a FLP, a family limited partnership, recommended? And so those became really, really popular when the state tax exemption was $600,000 per person, and one could have very little income to pass on to heirs and that sort of thing without being subject to tax. So all these, we came up with lots of different ways to try to gradually pass wealth on to children, and family limited partnerships was a very important component of that. The current estate tax limit being $11.58 million a person, which is over $23 million a couple. We're not seeing nearly as many family limited partnerships as we did back in the day. So it's something that is not used as often as it once was. But for those who are going to have taxable estates, oftentimes we'll use corporate entities, and it doesn't necessarily have to be a family limited partnership. It could be a limited liability company. There are other avenues that you can use. But if we have mom and dad who each own 50% in their family owned business, if we start creating partnerships or limited liability companies, and we bring in a son or daughter for 1 or 2%, and then dad dies, and instead of having 50 or 51% or 100% of the stock in the business, he owns 47%, then maybe we can get a minority interest discount and a discount for a closely held business, lack of liquidity. So it's a pretty high level technique, unless you're wanting to do something that's more guided strictly for how to transition the family business to one child or the other. So anything you think you want to add to that, Erin?
Well, when I use a family limited partnership, I typically am using it because we want to keep control in the general partner, who is typically mom and dad. So we may be gifting pieces of an asset or a financial account, et cetera, to kids, but we want to maintain the management in one specific person. Whereas with an LLC, the more of the member interest that you accumulate, the more power or voting power you get, and that lessens the discount and or brings all sorts of discord when children start out voting parents. So I still use the family partnerships a lot, especially in large ranches, in large financial accounts or stock holdings. And I use them very often for big gifts when we're planning to do a lot of gifting and getting assets out of an estate. So I love family limited partnerships. So but I'm prejudiced that way, or biased that way. All right, I have a question here. What rights does a long-term, not married partner have to your assets if you should die without a will and you own a house together? None. I mean, I'm pretty much saying, unless you have written a will and designated that long-term partner a owner of that property or a beneficiary of that property. Basically, under Texas law, we no longer have, it's very hard to prove a common law marriage. So you really don't have the same rights, even though you've been together for 30 years, you do not have the same rights as a person who is married. So in those cases, we always recommend that you do a will, making very clear what your intent is with that married partner or that unmarried partner. If you have a not married partner who's living with you and has for the past 25 years, and you have 3 kids by a previous marriage, they are going to throw that person out of that house and take it. So it's always very important, in my opinion, to write those intents down.
Yeah, and I see in the question, it says, if they own the house together, well, just because you own the house together, even if that's true, doesn't give you any rights. So the children who inherit the deceased partner's half can sue for partition by sale, and it's still the same thing. It's out you go. So that's still something that should be addressed instead of just let the collision happen when it happens. See another question here. When does the estate tax sunset? All right, so the compromise was reached many years ago, and maybe not all that many really, but to get to make the estate tax exemption $5 million, and to index it for inflation. So everybody thought this kind of takes care of it. Nothing's going to happen, and we've got certainty. And so it kind of grew every year till it got to like 5.46 million. And then we had a bill that basically, as part of one of Trump's first budget bills, doubled it. And so then it doubled and is still indexed for inflation. And so it's currently $11.58 million per person. It's going to continue to be increasing or adjusted upward by virtue of inflation. But the uptick in it stops on December 31st of the year 2025. So in 2026, January 1, we roll back to the 5.5 million. We increase it by whatever inflation adjustments would take place. We can't tell you what that is because we don't know what inflation is going to do for the next 5 years. But they will then calculate what inflation adjustments would be made to the reduced rate. But basically, January 1 of 2026, it will be half of what it was in 2025.
It will sunset, unless they sunset it earlier, which is likely.
And so in order for it to continue and be reaffirmed, it would appear as though one party must control the White House, the Senate, and the House of Representatives, and we all can probably figure out which party that is. But if the other party is in control before that happens, then it's subject to being repealed earlier than the end of 2025. So there's a saying that no one's safe while the legislature is in session. So that is certainly no more true than here. So we just don't know when that's going to be. But unless something changes, January 1 of 2026, we'll have a new ball game. All right. Not seeing any more questions out there, so we gave some people some more time. I think we've about handled them. Mm-hmm. So really want to thank all of you for joining our first virtual Wine and Wills. Hope you found this helpful. Going to try probably to do this. Yes, cheers to you all. And I hope you found this fun and entertaining as well as informative. So we may do these again from time to time, and if we all get the cure, then perhaps we can go back to doing them in the comfort of people's living rooms in a much more comfortable environment. Although you may have enjoyed just doing it this way, and you may prefer to still do it this way. So thank you for joining us. Again, if you have questions that we didn't answer or you think of later, just send them to info@tcvlaw.com. and we'll try to field those questions. So thank you, everybody, for coming, and we hope to see you around soon.
Stay safe, be well.